Hello, Ann.
Good morning, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-5040, Katrina L. Webster, appellant, versus Carlos Del Toro, Secretary of Navy. Mr. Clovers, amicus curiae for the appellant. Mr. Hare for the appellate.
Counsel amicus for appellant, please proceed.
Thank you, Your Honor. May it please the court. There are two errors in this case. First, the district court applied the incorrect legal standard when dismissing Mrs. Webster's complaint below for failure to, quote, clearly enumerate her argument and for failing to, quote, reference the relevant EEO complaint number in either count of the complaint. That is not the requirement this court set under Webb versus U.S. Veterans Initiative, under which, quote, courts must consider a pro se plaintiff's complaint in light of all filings before dismissing for failing to state a claim. Had the district court looked at all filings, including her opposition to the motion to dismiss, it would have found ample evidence of a reprisal by disclosure claim, including at JA 6 and JA 13 in the complaint, JA 89, 91, and 93 in the opposition to the motion to dismiss. Second, the Navy asked this court to compound the error by in the alternative ruling that Mrs. Webster failed to exhaust her administrative remedies. That argument is waived, as I've discussed in the brief, because they first raise it in the motion for summary affirmance as arguably less than fully exhausted. And then in concluding, they ask this court to disregard Mrs. Webster's arguments on the issue because it was not part of the district court's decision, and therefore they were seeking affirmance only for the reasons the district court gave.
They don't need to put all of their arguments in a summary affirmance motion.
No, but in this case, it's not forfeiture but waiver. They've directed the court's attention to the issue, and then they've asked you to disregard it. Even if not waived, though, if you were to look at the merits of that claim, you would find that Mrs. Webster has satisfied both conditions. So at the time that she filed in federal district court on March 2nd, the EEO decision of February 14th was final. And the Navy did not file their motion for reconsideration until 2 weeks later on March 16th. So on March 2nd, the EEO's decision was final, and under 29 CFR 1614.407, she had 90 days to file, which she did.
Two requirements that are relevant here. One is statutory requirement that the exhaustion has to be done for the employing agency, not the EEOC. And another is the regulatory requirement of issue preservation. EEOC reg says that the administrative complaint has to generally describe the actions or practices that form the basis of the complaint. So why does that combination establish preservation issue exhaustion requirement before the Navy? The Supreme Court has said, and we've said, exhaustion means proper exhaustion, which means raising issues as required by the governing regs.
Well, Your Honor, she did so.
Where did she raise this claim? Retaliation by disclosure to the deputy before the Navy.
She raised it on March 20th in her informal complaint on April 11th, and then again in her interview on September 24th. And this is all evident from the Navy's report of investigation, which is Exhibit 5 to the motion for summary reversal, in which the Navy says that its investigation covered, quote, reprisal for an prior EEO activity.
That was reprisal related to the disclosure of her EEO activity to Yamin.
That's correct. And if it's not clear, that's because the Navy had no interest in investigating the issue. There are several times that Mrs. Webster tried to bring it to their attention, and the Navy kept trying to characterize it as something else.
But the EEOC characterized it as something the EEOC was raising sua sponte, a claim that she wasn't pressing in the administrative appeal.
They did say that, but that's inconsistent with the record.
That's, sorry.
Inconsistent with the record.
Okay.
We assume that the disclosure to Yamin was materially adverse. Where in the complaint do we find that you've pled any kind of Iqbal Twombly specificity, plausibility, that the disclosure to Yamin was caused by her previous EEO activity?
Well, Your Honor, I think it's actually clearest as to Garland, if I may go there. So as to Garland, she pleads the disclosure to him as well. It's most clear in her opposition to the motion to dismiss. And at JA 91 and 93, she says that it was done for the purpose of dissuading her from EEO activity.
JA 91 and 93, I think, are not part of the complaint, unless I'm misremembering JA.
That's correct, Your Honor. They're part of the opposition to the motion to dismiss. And under Webb, the district court should have considered all the pleadings in the case before dismissal.
And
But the only claim, I thought the only claim still open in the case involved the disclosure to the lieutenant. Is it Yamin?
I don't think that's right, Your Honor, at least based on the briefing. I think she says generally reprisal by disclosure, and then in the opposition to the motion to dismiss, she provides further detail. There's really at least two disclosures. So there's disclosure to Yamin, on which there's disputed evidence of whether or not he's a manager. There's the disclosure to Garland, on which there's no dispute that he is not a manager. And then there is also a Mathis declaration that she submitted along with her complaint, which says that there were general rumors circulating, which suggests that the disclosure was not limited to those two.
Well, I'll look at Garland when I review this, but the two retaliation theories I remember by disclosure, one was disclosure to the coworkers, and then this chatter that they view her as trouble, and that's a problem for her, and that's no longer in the case. And the other is the disclosure to Lieutenant Yamin.
No, I think
So you think there's a third one, disclosure to Garland, that we need to deal with?
that's right. That's right. So Garland is the one who said she is trouble. What was dismissed below was some of the actions that he took, but not the
He's a coworker or a supervisor?
He is not a supervisor. He's a contractor.
Right. As to Yamin, suppose the Attorney General learns of an EEO issue like this, someone he deals with in the course of his duties, and he goes to his chief of staff and discloses the EEO activity and asks for advice. How should we deal with this? And the chief of staff is not in the chain of command of that person. Would that be an unlawful disclosure?
In this case, since it's for the purpose of legal advice, I would say no.
If that's all you knew, you wouldn't think that's unlawful, right?
Correct. Not for the purpose of legal advice. I agree.
Okay, so why isn't this case more like that than like the case where the retaliator puts it on the intranet and everyone in the company knows this person is trouble?
That's right. So I think the Navy at brief 20 describes the case Moganam v. Napolitano from this court, in which they say a broadcast situation would be unlawful. And I think the facts here are much closer.
In the circumstances of that case, right? The broadcast to a bunch of coworkers who have no management or business reason for knowing that.
That's right. And I think the facts here are closer to that than a single private conversation insofar as we have a disclosure to Yamin, we have a disclosure to Garland, and we have general rumors.
Well, but Yamin, so just focus on Yamin. I mean, Yamin is sort of, the Navy says he is Crowley's, I don't know, deputy lieutenant, close aide to Crowley, and you say Yamin is not in the chain of command, in Webster's chain of command.
I say the evidence is disputed, Your Honor. That's right. The EEOC says that before the EEOC, the Navy agreed that he was not in the chain of command. I think there's contrary evidence as well, and so on that record, it's better to remand and let the district court figure it out. There are no further questions, Your Honor?
I do have.
Oh.
Let's assume that all of the facts that you've pled are correct. What was her injury?
So the injury was both pecuniary in the sense that she was not promoted and therefore received a lower salary. I think there was also injury just in the process through which the Navy has resisted investigating, which is precisely why she's ended up in federal court. You know, she's been in this administrative quagmire now for 5 years without even getting a clear declaration from Garland that is signed and dated. So part of what she's seeking is the vindication of her rights to an investigation. Thank you, Your Honors.
All right, counsel for the Navy.
Yes, good morning. May it please the court. Christopher Hare for Appellee Secretary of the Navy. We ask that you affirm the district court's dismissal of Ms. Webster's remaining claim for 2 reasons. First, disclosing someone's prior protected activity without more is not against the law. Ms. Webster's complaint alleges that her supervisor, Captain Patrick Crawley, unlawfully disclosed her protected activity to another manager in her branch, Lieutenant Tarek Yamin. It says no more than that. Her complaint in opposition to the government's motion to dismiss do not clarify this claim any further. Rather, Webster speculates that Captain Crawley may have disclosed her protected activity to another employee, Mr. Richard Garland, an IT contractor who worked at the help desk. Even assuming the truth of Ms. Webster's well-pled allegations, she fails to state a plausible claim of retaliation. The disclosure to another manager or even to another employee would not dissuade a reasonable worker like Ms. Webster from making a charge of discrimination. As my friend on the other side just discussed, Ms. Webster claims that she was not promoted in over 21 years. But that claim is implausible, where she does not allege that she applied for any specific promotion as required by this court's precedent in Latham versus Snow. And Mr. Garland—
Are the promotion claims live?
No, Your Honor. Well, I believe, Your Honor, that the promotion claim deals with the hostile work environment. Because if you look at her pre-complaint counseling, which amicus is pointing to—
Is the hostile environment claim live?
That is not.
I thought through some combination of res judicata and the special panel's order in this case, the only live issue is the theory of retaliation by disclosure to Yamin.
Precisely, Your Honor. And I think Ms. Webster has been fully heard on that issue, and it is no longer a live claim in this case. So there's a disconnect, a clear disconnect between the unlawful disclosure claim and a claim that would have something more to do with non-promotion. And that makes sense. Mr. Garland, as an IT contractor, certainly wasn't in charge of any promotions. And I believe the reason that Ms. Webster had pointed to in her pre-complaint counseling with the EEO counselor had to do with the types of hostilities that she was experiencing or the statements from her coworker. And as I just noted, that claim is no longer live in this case. So I believe what is being suggested here is something akin to a strict liability regime, whereby an employee could inflict liability on an employer by the mere utterance of prior protected activity, seemingly for any reason. And as we noted in our briefs, confidentiality is often a good idea, and and that is generally required through the EEO investigation process. But there are many legitimate non-retaliatory reasons for a supervisor to discuss protected activity with another employee. And just to kind of clarify for the record, the issue of whether or not Lieutenant Yamin was her supervisor, he did not author Ms. Webster's performance appraisal. He was the branch deputy and therefore would supervise her work and maybe assign her work, but was not directly responsible for,
What do we know about the relationship between Crowley and Yamin? Is it like my hypothetical of a principal officer and a chief of staff?
I don't think
principal deputy or something like that.
I don't think it's that intimate, Your Honor. It's admittedly not in the record exactly what their working relationship was, but yet they're all working in the same environment as managers, as maybe leading different groups or subgroups within the office. And the Captain Crawley was superior, and they would both. So Ms. Webster worked as Captain Crawley's executive assistant. But as those types of roles, as the court might appreciate, have broadened over the years, Ms. Webster's services may be utilized elsewhere in that office, including by the branch deputy, Lieutenant Yamin. The second issue, Your Honor, if I could move on to exhaustion, her EEO complaint, which she never amended, did not raise any retaliation by disclosure claim. And we do not find any evidence in the record or joint appendix to show that the Navy investigated as such. As we note in our briefs, knowledge of prior protected activity is but one element that the Navy may have considered when investigating Mr. Garland's conduct. And there were statements alleged in the EEO complaint, which was specifically focused to the exclusion of Captain Crawley, as we note, on Mr. Garland's conduct, that in order to be retaliatory would have to bear some knowledge to the prior protected activity, but that was not the underlying claim, and for that reason, the Navy had no reason to go and investigate it during its process.
Let me ask you, as I understand Amicus's point, maybe it's a technical matter. If you look at specific allegations, you won't find this retaliation. But if you look at all of the pro se filings, you will. So what I'd like to understand is what is the government's position on how much leeway this court is required to accord to a pro se litigant?
Yes, Your Honor. I think as a pro se litigant, Ms. Webster is entitled to every reasonable inference based on the factual allegations. First, I'll point out that there's a significant disconnect between an allegation of disclosure by Lieutenant Yamin and then in the opposition to the government's motion to dismiss, talking about an entirely separate issue, which is whether or not Mr. Garland had knowledge, and if so, where from. So off the bat, we're kind of talking about apples and oranges here.
And we're not talking about, from your point of view, the pro se's point of view, just a series of incidents here that stood in her way one way or another. And while she may not have mentioned everything as you would hope a lawyer would, nevertheless, the Navy knew what was up. This is not a surprise that she's complaining. So I get your point about, contrary to what Amicus was arguing, well, the Navy did investigate the sort of surrounding circumstances. But your position is that is just an incorrect statement or an incorrect reading or interpretation of the Navy's investigation?
I believe it is an incorrect sort of characterization of what issues the Navy was investigating here. And, I think that also gets to the fact that the complaint itself, as Judge Katsas just asked about, was related to a hostile work environment claim, and that claim made sense. Ms. Webster was experiencing maybe statements that she interpreted to be unkind and would lend itself to some support of a potential hostile work environment. But as we pointed out in our brief, this is not the case where a manager was broadcasting a complaint and doing other things that we can glean from the papers, even giving her every inference in her favor and assuming the facts of any factual matter, where we can discern that was the type of claim, a retaliation by disclosure type claim that she was attempting to bring here.
I understand that disclosure by broadcasting, but I'm not sure I understand that to be the sine qua non for a hostile environment, an adequately alleged hostile environment claim. In other words, that's one way to argue, the employer is liable, but that's not the only way.
No, Your Honor, I think there would be a number of additional facts that a plaintiff might allege to nudge this over the line of plausibility. Our position is simply that given what we have in the complaint, and even given some of the speculation that we have in the opposition to motion to dismiss, we're not making out a plausible either broadcast claim, which I understand is its own type of claim that we don't discern here, or any other type of discrete act of retaliation, which is the Supreme Court noted in Morgan is quite different than a hostile work environment claim. So I think you're right, Your Honor. There may be some background information or some context that we ought to consider when looking at the complaint, but here we don't have that factual material. And if I could just note, there were some portions of the joint appendix that amicus pointed to regarding the rumor mill, let's say at the office. Those rumors and affidavits that amicus cites to are from back in 2005 and 2006. And the complainant issue that we're talking about here deals with the 2017 timeframe. But that further, I don't think that shows plausibility anymore. And in fact, I think if there's a rumor mill going on that long ago, well before Captain Crawley joined the office, I might add, it does not show that there's a sieve of information, so to speak, about protected activity and knowledge thereof within the office.
Her administrative complaint does allege retaliatory disclosures, at least in general, as relevant to hostile environment, correct?
I think we would dispute that, Your Honor.
Okay. Why?
What the complaint actually says is...
The administrative complaint.
The administrative complaint, correct. And the one that was accepted for the investigation talks about the conduct from Mr. Garland that Ms. Webster deemed to be retaliatory in some way, that he was, I believe, the complaint is critical of her prior protected activity. As I stated before, and as we stated in our briefs, it would have to have some nexus to prior protected activity, but the fact that he was critical in and of itself doesn't lend itself to a disclosure claim, much less one that, bring forth enough facts to put the Navy on notice that there was such a claim.
I think I'll ask amicus a question that I meant to ask earlier, but I want to give you a heads up since you won't have a chance to then speak after the amicus. If I Google Katrina Webster, Navy discrimination, there's hit after hit after hit of court filings regarding her EEO activity. It's not that there's, people, it's court filings, public record. is the most narrow way for us to decide this case to say there's no disclosure of private information when it's already public information?
I believe that would be a rather narrow way, Your Honor, and you know, as the district court said, that it could not glean a retaliation by disclosure claim here, but if there's evidence in the record to suggest that her prior protected activity was well known in the office, and there's no factual assertion in the complaint or otherwise that would show that that knowledge was somehow propagated by Ms. Webster's management, much less Captain Crawley. If there are no further questions, we ask the court to affirm.
Could I just ask counsel, so I'm clear, you are responding to Judge Walker's question, but there's a clause in your answer that I'm not sure I understand. What is your response to at least what I understood to be the implication of Judge Walker's question? Namely, that this woman has been working there a long time and she's been dissatisfied for a number of reasons. That sometimes, you know, it's the rumor mill, at other times it's something else, but it's just going on and she's not getting what she considers to be her due satisfaction. And isn't it enough to sort of be somewhat vague about this where you're a pro se litigant? And I hear you saying, well, there may be some leeway due, but not so much leeway that the Navy has to speculate as to the specific allegations underlying the complaint at issue here. Am I characterizing your response?
I do believe you are correctly characterizing my response, Your Honor. We are asked to speculate here, which has problems both at the exhaustion level to put the Navy on notice and give us a fair chance to investigate. And then it also assessing the sufficiency of the complaint doesn't allow us to nudge this claim into the realm of plausible. So for those reasons, we're asking the court to affirm.
Your Honor, just briefly, two things. First of all, having heard opposing counsel's argument, I think, although opposing counsel seems to agree in principle that pro se litigants are due additional deference and you should look at all the pleadings, that's not, in fact, the argument. The argument seems to be that we should construe every inference against her as evidence that it is somehow ambiguous. And second, as to the point about Google, I think all that shows is, as Judge Rogers said, that Mrs. Webster has been here for a while and has had several problems in the course of her employment. And also that, as the EEOC found, the Navy does not take its confidentiality obligations seriously. And so, of course, in the course of previous EEO investigations, they've been disclosing potentially all sorts of things.
No. This is like a cert petition that her husband wrote regarding her EEO claims. It's not, these are court files.
No, but the EEOC found that the Navy does not protect the confidentiality of any of its investigations. And so to the extent that opposing counsel is pointing to a 2015 or 2016 affidavit and saying that has nothing to do with our case, it does, to the extent it demonstrates the Navy was not interested in confidentiality in 2015 or in 2017. If no further questions, urge reversal and remand. Thank you.
Case number 21-5119, Joseph Michael Ladeairous, appellant, versus Merrick B. Garland, U.S. Attorney General, and Michael E. Horowitz, U.S. Inspector General. Ms. Durojaye, amicus curiae for the appellant, Mr. Dreyer for the appellees.
Counsel for appellant?
Thank you, Your Honor. Erica Hashimoto as court-appointed amicus in this case. With the court's permission, Odunayo Durojaye, a third-year law student at the Georgetown Law Center, will be presenting argument on behalf of amicus.
May it please the court. Rule 4A6 was promulgated for situations like this. Mr. Ladarius did not receive the district court's order until 69 days after it was entered. Shortly after he received the order, he sought to appeal it, but filed an incomplete Rule 4A6 motion to reopen. Once he was on notice that his motion to reopen was incomplete, he supplemented it with additional information as to why he qualified for Rule 4A6 relief. This court should construe his documents as a timely filed Rule 4A6 motion to reopen, because when applying the doctrine of contemporaneous filings, Mr. Ladarius' motion to reopen was timely.
When you say an incomplete motion to reopen, you're referring to the notice of appeal.
Correct, Your Honor.
It's a pretty expansive notion of what a motion to reopen is.
No, Your Honor, because the reason it's an incomplete motion to reopen is because it did not specify that Mr. Ladarius did not receive the district court's order within 21 days of it being entered. In the 9th and the 11th circuits, when a notice of appeal included those reasons, they were construed as a timely and complete motion to reopen. And so too are they here. Mr. Ladarius' notice of appeal with the response to the order to show cause are a timely and complete Rule 4A6 motion to reopen, and this court should consider the information that he provided in his response to the order to show cause because of the Supreme Court's longstanding history of considering contemporaneous documents for imperfections of form. In Foman, the Supreme Court allowed an untimely notice of appeal and a timely notice of appeal to determine that the appellant had sought relief of both the underlying motion for the underlying denial of the motion to vacate, as well as the order that the appellant had sought review of. And this court should do the same here and consider the timely notice of appeal with the response to the order to show cause that was filed outside of time. And this court should apply the doctrine of contemporaneous filings to Rule 4A6, because when this court applied the doctrine to Rule 15 did not have a provision in it that stated an appeal should not be dismissed for informality of form. Nonetheless, this court applied the doctrine to Rule 15 and allowed a variety of contemporaneous documents. This case falls comfortably within the precedent set in Sinclair. In Sinclair, experienced counsel failed to satisfy the requirements of Rule 15A, which are jurisdictional, but this court allowed a contemporaneous document to satisfy those requirements.
Why is a document filed 39 days late contemporaneous in the context of a rule whose entire time horizon is 14 days?
The document is contemporaneous because in this court, in small business and telecom, this court defines contemporaneous as at or near the same time. And in Sinclair, 34 days was contemporaneous.
34, yeah, but 39 versus 34 is helpful to you.
Yes.
But, I mean, neither of those sounds hugely contemporaneous to me. We're talking about at least a month. And one difference between St. Clair and here is the underlying time period in St. Clair was 60 days for you're 34 days late relative to a 60-day period. Here, you're 39 days late relative to, even if everything goes perfectly, you only get 14 extra days.
Yes, Your Honor. However, in Sinclair, that document was still filed outside the time limitations for the petition for review. And in this case, when you apply the doctrine of contemporaneous filings to Rule 4A6, the incomplete motion to reopen was still filed within 14 days of receiving the district court's order. And so when the doctrine of contemporaneous filings is applied, May 17th is the governing date of the motion to reopen because the information in the response to the order to show cause is only meant to supplement the information in the incomplete motion to reopen.
Sorry, walk me through that. How do you get 14 days on this timeline?
Mr. Ladarius received the district court's order on May 4th, 2021,
Right.
and he submitted his notice of appeal, which was an incomplete Rule 486 motion to reopen on May 17th,
Okay.
2021.
Okay.
And so because that was filed within the time limitations of Rule 486, even though it was incomplete, when the doctrine of contemporaneous filings is applied, May 17th is the governing date of the motion to reopen. And the governing location of the motion to reopen is the district court.
But it's the document that cures the defects that has to be contemporaneously filed, right? That's the response to the order to show cause.
Yes. And this court should consider the information in the response to the order to show cause because when this court applied the doctrine to Rule 15, the provision in it did not state that an appeal should not be dismissed for informality of form. Nonetheless, this court applied it, and so too should they do the same in the context of Rule 486. And when you look at the substance of the documents that were contemporary of the motion to reopen, they are satisfy the requirements of Rule 486 because they allege and they assert that he did not receive the district court's order within 21 days. And he also provides proof of not receiving it with the stamp of the notice of the district court's order being set for May 4th, 2021. And the Supreme Court has emphasized an elevation of substance over form. And so because these documents together are the functional equivalent of a Rule 486 motion to reopen, that substance should be elevated over the form that the documents contain. And the form is also not dispositive because the courts of appeal agree that a Rule 486 motion does not need to be formal. And so because Mr. Ladarius included the information, this court can consider the documents as a timely and complete Rule 486 motion to reopen. And the documents together satisfy the requirements of Federal Rules of Civil Procedure 7B1 because they are in writing, they state the grounds for relief, and they ask this court to not dismiss for his appeal or not dismiss his appeal. And this court also has the discretion to forward his documents, and so this court should, because it is unjust when an appellant who did not receive the district court's order filed a subsequent document in the wrong court. It would be unjust not for this court to forward that motion when Mr. Ladarius asserts that he did not receive the district court's order within 21 days of entry and includes that information.
How would you define an incomplete motion? Just as a general matter.
An incomplete motion to reopen would not include that the appellant did not receive the district court's order within 21 days of entry.
What about just even more generally, not even in the context of the appeal? Is an incomplete motion a term that you're using and think applies?
No, Your Honor, for a Rule 486 motion, in order for it to be complete, it would need to have been submitted and include the information that he did not receive the district court's order and within 21 days. And so because that information is missing, that is what would make the motion to reopen is incomplete. And in conclusion, this court should construe his documents as a timely file Rule 486 motion to reopen. There are no further questions. Thank you. I would like to reserve the rest of my time for.
Thank you. So, counsel for appellees.
Good morning. May it please the court. Douglas Dreyer on behalf of the Attorney General and Inspector General. The heart of this case is that Mr. Ladarius filed an appeal more than 6 days after entry of judgment and did not timely file either a Rule 485 motion for extension or a Rule 486 motion to reopen. Mr. Ladarius admits as much on page 17 of his opening brief and on page 4 of his reply brief. Now we are here on an abuse of discretion standard, asking whether the district court abused its discretion in failing to rule on a motion never filed. As Mr. Ladarius failed to comply with the rules and with 28 USC 2107, the court should dismiss this untimely appeal for lack of jurisdiction.
Well, I mean, we're here on a legal question, whether the original filing, the notice of appeal is close enough to a 4A6, and whether the curing document, the response to the order show cause, is good enough and was filed soon enough, right? Those are legal questions.
Yes, but if there was a Rule 4A5 or 4A6 motion, then the district court's order would have been ruled on based on abuse of discretion. And here, there is no dispute. My friend agrees.
Sure, but I mean, we haven't reached that point.
Correct. But there's no dispute that a bare notice of appeal is insufficient to constitute a Rule 4A6 motion to reopen or a Rule 4A5 motion for extension. And the sole question is whether a response to a show cause order that was filed in a different court on June 23rd, well after his deadline to file either such motion, could be treated as a motion to the district court when it was a response. If there are no further questions, I thank the court and I ask for dismissal.
Thank you, Your Honors. The government wrongly says that this is a bare notice of appeal. This does not fall within any of the cases that are bare notice of appeal, which would be in not a motion to reopen. This is a situation in which the notice of appeal was supplemented with additional information as to why he qualified for Rule 4A6. Thus, any precedent that was set on a bare notice of appeal does not apply here, especially because a notice of appeal does not need to be formal. All that it has to do is a motion to reopen does not need to be formal. All that it has to do is allege that the appellant did not receive the district court's order, and that is what Mr. Ladarius did. He told this court that he did not receive the district court's order.
I mean, it has to ask the district court for more time, and it has to show lack of prejudice on the other side. I mean, there are elements to this rule, and there is a court in which it has to be filed. And the order to show cause response doesn't tick off those elements, doesn't tick off any of that. Just asks for an equitable extension of the 60-day period, which we might like to do, but we know from Bowles that we can't.
Your Honor, this is not an equitable exception because when this court applied the doctrine of contemporaneous.
No, but the order to show cause opposition says you consider my appeal timely because I didn't get notice in time to file.
Yes, Your Honor, but he also states that he did not receive the district court's order, and that is enough for a Rule 4A6 motion to reopen because he did not receive it. And no particular words are necessary for a motion under Rule 4A6, but alleging that is sufficient. And although Mr. Ladarius did not include that the government would not be prejudiced, the government has yet to offer a reason as to why they would be prejudiced. And having to appeal the case or to go through the case would not be a reason to allege prejudice. And on your note of the district court, this court has the discretion to forward it to the district court to put the district court on notice, and it should exercise this discretion.
Could I ask you whether or not you're familiar or not with the district court's pro se procedures?
No, Your Honor, I'm not familiar.
Thank you.